Because a lease is a contract, the lessor can enforce the lease's obligations against the lessee for the entire lease term, even if the lessee is no longer in possession of the property. If the lessee assigns the lease to a third party, does the assignee automatically take over the lessee's obligations, including liability for rent throughout the lease term? That's the question in A.D. Juilliard and Company versus American Woolen Company. In May of 1893, Atlantic Mills leased property to Riverside Worsted Mills for a term ending in September 1955. The lease had no restrictions on assignments, nor did it provide for an assignee to assume the lease's obligations for the remainder of the lease term. Subsequently, the lease was assigned to the American Woolen Company. In 1939, American Woolen assigned the lease to another entity. None of the assignees specifically agreed to pay rent for the remainder of the lease term. In 1941, A.D. Juilliard and Company, Atlantic Mills' successor in interest, sued American Woolen to recover unpaid rent due in 1940 and 1941. The trial court ruled for American Woolen. Juilliard appealed to the Rhode Island Supreme Court.